Thank you very much for turning out on yet another, as we say in Scotland, Dreich day. Apologies for the late start. Dr. Edgar is somewhere right now and hopefully on his way. He's coming down from Providence, Rhode Island. But we'll start the proceedings anyway. Lunch is being served as I speak. So let me start by introducing our panelists. First we have Professor Brian Ford, who's Professor of Computer Science at Yale University, where he leads the Decentralized Distributed Systems Research Group at Yale. His work focuses broadly on building secure systems, touching on many particular topics, including secure and certified OS kernels, parallel and distributed computing, privacy-preserving technologies, and internet architecture. Professor Ford earned his Bachelor of Science at the University of Utah and his PhD at MIT. So no slouch. And then we're also joined by Mr. Daniel Gallington, who's the Senior Policy and Program Advisor at the George C. Marshall Institute. Mr. Gallington is the former bipartisan General Counsel for the United States Senate Select Committee on Intelligence, a former Deputy Counsel for Intelligence Policy at the Department of Justice, and a former Deputy Assistant Secretary of Defense for Territorial Security and Special Assistant to the Secretary of Defense for Policy. And hopefully when he arrives, we also will be joined by Dr. Timothy Edgar, who's a visiting scholar at Brown University's Watson Institute for International Studies. Edgar served under President Obama as the first Director of Privacy and Civil Liberties for the White House National Security Staff, focusing on cybersecurity, open government, and data privacy initiatives. Under President George W. Bush, he was the first Deputy for Civil Liberties for the Director of National Intelligence. Prior to his government service, Mr. Edgar was the National Security and... I was just singing your praises, Mr. Edgar. Please take a seat. I'll start again, actually, so Mr. Edgar can hear the great things that we're going to say about him. So, as I said, Mr. Edgar is the visiting scholar at Brown University's Watson Institute for International Studies. He served under President Obama as the first Director of Privacy and Civil Liberties for the White House National Security Staff, focusing on cybersecurity, open government, and data privacy initiatives. Under President George W. Bush, he was the first Deputy for Civil Liberties for the Director of National Intelligence. Prior to his government service, Mr. Edgar was the National Security and Immigration Counsel for the American Civil Liberties Union, and he has a JD from Harvard Law School, where he served on the Harvard Law Review, and an AB from Dartmouth College. My name is John Sheldon. I'm the Executive Director of the George C. Marshall Institute. Again, thank you all for turning out on such a miserable day with the weather. And I will now hand over to Dan Gallington to set and frame our discussion. Dan, the floor is yours. Thank you.
Thank you. It's my intent to take a few minutes just to do a sort of a scene setter, political perspective, as you will, for the issue we're going to discuss today. I'm reminded whenever I do one of these things of a conversation I had with my mom, who lived to be about 90. We were watching a PBS show on government surveillance, and my mom turned to me and she said, I know that this is what you do and you have done for many years, but she said, I just don't think the government ought to be able to listen to anybody's conversations. I don't care. I said, okay, Mom. And I didn't want to get into the technicalities of how intricate a process that was. So I said to her, okay, Mom, what about terrorists and spies and kidnappers? And she looked at me, and she just, 5 seconds went by, and she looked at me like, well, you little 5-year-old kid. Well, she said, those kind of people, sure. So I kind of think that that's the way most people look at these series of issues we dealt with, the intersection of security and privacy over the years. These things are all threat-driven. Could I have a slide? These things are all threat-driven. both law enforcement and the intelligence parts of our government are threat-driven. They always have been, they always will be. Will Congress / the President permit truly inaccessible information to exist? I kind of think the answer to that is I doubt it. They never have in the past, and they're struggling again with that issue. I can offer up some historical examples. When I first heard the encryption issue explained to me, it was when I was at Justice in the old office of OIPR there, where I worked for many years. And again, when I was general counsel for the SSCI, the context that we were briefed about encryption was always in a revenue standpoint, a revenue generating function. And I wonder how much of the issue today is still in that category, although the respective economic leverage of the people involved has changed drastically over the last few years. You might remember when Mama Bell broke up and the small cell phone companies began to spring up all over the country, FBI and the intelligence community was aghast because there was nobody at these new companies who knew how to deal with warrants presented by law enforcement or FISA. And so I sent lawyers from my office all around the country to try to educate the new managements of these companies about what their responsibilities were. It was an enormous task, and we eventually had to go to Congress and say, help us, throw some money, please, at these companies. And later this was extended to internet providers, and the whole concept, those of you in the business, we went to what we called trusted agents to allow this function to be carried out. But I wonder whether or not we're at a similar stage in the issue with encryption as we were with Kalia. Next slide. It's hard to see, but the key questions that all of us have when we're worried about our national security, our public safety, and our privacy all at the same time, like my mom was, we're worried about thresholds. What kind of thresholds are created? What are new ones? How are they going to be managed? How are they defined? What's the duration? How aggressive is the oversight, which is the issue we're involved in now with the metadata issue, aggressiveness of the oversight. When does government actually have information? What's the difference between access to and have? How intricate is the process to actually look at the information? And who looks at it? Who decides? Who assesses the value of the take and whether or not it's worthwhile to continue to look at information that you have to get with such a procedural complexity? And who approves continuation of the program? In this context, it's good to remember where we are right now with the metadata issue. Next slide. Here's a program that was started by the president. Congress objected because they weren't involved in the program. The president said to Congress, okay, if you don't like it, facilitate it, enable it with statutory changes, and they did. FISA, the Patriot Act, and several other statutory changes, the Congress enabled essentially the president's program. Snowden outed the program, and all of a sudden, Congress said, well, now, we're not sure we intended to do that. It wasn't well managed. I didn't know about it. It's far beyond what we intended. The president appointed a commission to study it, and now we no longer do the metadata thing. Remember, historically, TIA, post 9/11, the DARPA program, we have the same outrage with privacy that we're having today. And the president appointed, or the Secretary of Defense appointed Newton Minow to run a commission. We had a commission. And that issue now is settled down to the point where I'd like you to encourage you to take a look at the privacy statements drafted and online by Department of Homeland Security as they pursue their statutory charter to become situationally aware of threats domestically. What I'm saying is essentially that the TIA program, with hopefully not all its warts and scars, but the TIA program in large extent is in place and run under very, very closely written privacy standards in the Department of Homeland Security. So, with further ado, John has brought today for us the two guys in this country, and I'm telling you that know more about this than probably anybody else. They're from out of town, and obviously they do. And one of them, my friend Tim Edgar, I have experience with in the past, and he's looked at it from a lot of different ways. And Tim, you might remember when we testified in front of HPSI 11, 12 years ago, I said something in my written statement that I wish I'd have said in my oral statement. But the operative facts is as much how the data is associated with an identity as it is the limitations on collecting or initially sorting the data. I think we're still with that same kind of threshold when we're talking about encryption. Anyway, without further ado, let's start with Brian and get figure out to learn about all the technical aspects of what we're talking about here.
Well, like Dan said, I'm primarily a technical person, so I will try not to resist my natural inclination to go into all kinds of technical detail about work we've done in this space, and I apologize in advance if my terminology doesn't line up perfectly with the legal and policy world, but I'll do my best. I would like to so I'd like to focus on. I'd like to try to summarize at a high level the capabilities of some of the modern cryptographic technologies that we have and have had for a number of years now that I think are very relevant to this whole discussion of privacy versus the needs of law enforcement. So some of my colleagues and I, like I said, have been working on a project in this space that we believe points in directions that if implemented both in a reasonable way in terms of both technology and in a suitable policy framework, could actually mitigate some of the perceived tensions between targeted intelligence capability and user privacy. In particular, we recently published and released a proof of concept system that actually that's inspired by in particular the phone records issue, and tries to explore how this kind of the phone records storage and search problem might be addressed in a privacy preserving fashion. In particular, how the storage of that data could be secured with proper use of encryption, and how it could be accessed under very, very constrained but still with very powerful methods for law enforcement. So I think the key properties of the approach that we've tried to explore, and I don't think this is new. I think I believe other entities in government have already, explored this before, but for whatever reason, it just hasn't actually been implemented. Some of the key properties are that with modern encryption technology, we can do a lot more than just encrypting something and storing it. We can do all kinds of processing on encrypted data and that processing can be done without the entity or agency that's doing the processing necessarily having the keys, the decryption keys that are needed to open the data. And that's an extremely powerful capability that leads to the capabilities of creating what we like to call open electronic surveillance and intelligence processes, where the process doesn't necessarily need to be secret, but it can still hide the details of an investigation and the details of the methods used in that investigation, while ensuring the privacy of untargeted users and the data about users not targeted in the investigation. So that's kind of the key goal. And to discuss the properties of the system, like I said, I'm going to try not to get into all the technical details, but I want to cover 4 of the properties of the approach that we've been exploring in terms of how they're specifically inspired by properties of the traditional search warrant process and the constitutional principles that are embedded in that traditional search warrant process. So the 4 particular principles that I'm referring to are, first, the idea of open processes themselves, that the warrant process is open in that the Constitution and public law defines what the process is for law enforcement to get a targeted warrant, at least traditionally, right? Now, that process doesn't define doesn't define, how the methods, the possibly myriad different methods with which law enforcement can and does and should use that one process. And some of those methods, can and probably should remain secret. But I want to try to distinguish between the notion of, the search process and the methods with which it's used. And I'll come back to that in a minute.
Excuse me.
Yeah.
You mean the search of the data?
So, yes. So let me try to. So let me try to outline this process in just a little bit more detail without getting into too much technical detail. So in brief, actually, let me summarize these 4 properties. So one of the properties is the idea of open process. We'd like to reflect that. Second property is separation of powers, right? This is deeply embedded throughout the Constitution and the way it applies to the search warrant process, in that a search warrant comes from one branch of government but needs to be authorized by a second, and a third branch is supposed to exercise oversight in that process. We have the technology to embed that separation of powers in cryptographic processes for storing and accessing metadata to ensure that no single branch of government or no single agency representing a single branch of government, and especially no, say, single rogue system administrator within one of those agencies can go and access the data in an unauthorized fashion, right? So we call this, in the technical world, we call this secret sharing or key splitting. So we can take basically any cryptographic key and split it into multiple pieces so that multiple pieces are required to decrypt any data. This is a very general and well-known technical capability that we've had for a long time. And I believe it can and should be used to embody and preserve the notion of the high-level policy notion of separation of powers in the way we implement processes to store and search user data. The third principle that I think is deeply represented in the traditional constitutional search warrant process is the notion of probable cause. And that, some level of evidence, I'm not a policy person. I'm not going to try to delve into all of the questions surrounding what threshold of evidence should be required before a search can be done or authorized. But just from the technical side, so I think one important question is, given the demands given the threats that are out there today and the demands for law enforcement agencies to be able to sift through the huge amount of information out there in order to target legitimate surveillance targets and get the information they need, do we need to weaken the standard of probable cause? Do we need to weaken it to something weaker, like reasonable suspicion? I think that's an important question. I just want to kind of speak to it very briefly from a technical perspective. I believe one of the key arguments that can be, and I think is made to try to suggest that it needs to be weakened, is that, well, it's when law enforcement needs to search through a needle in a haystack, they don't know the name and phone number and the precise personal details of a target they need to go after. They need to do some kind of more general, powerful search based on a description. They just need to they have only a list of times and places where some kind of criminal activity was known to have occurred. They don't have a name or phone number. They need to do this kind of more general search based on not an identity but a description, something more vague. Well, this is another situation where, given the place where modern technology is, at least there's no technology can handle this, even on encrypted data. We, in particular, in our prototype, we support specifically the types of searches that I just described. We look at a case. We're inspired by a particular case known as the High Country Bandits case, which was a few years ago out west somewhere, where some bandits had basically robbed a number of banks, and the FBI linked these cases together, but didn't really have anything to go on other than the places and times at which the robberies occurred. But one of the bandits had taken a cell phone along on these runs, and once the FBI was able to get the lists of cell phone numbers that had been in those areas at the corresponding times, they were able to find, there were of course lots of innocent bystanders in all of those areas. In fact, about 150,000 people, but of course only one phone number appeared on multiple ones of those lists, right? And so they got it, right? So this is a powerful capability that's demonstrated to be valuable and useful in law enforcement, and so these kinds of searches are needed, but these kind of searches also can be implemented without violating the privacy of the 150,000, without just kind of dumping in the clear text the 150,000 users who were just in one of those areas and had nothing to do with this particular crime, right? So one of the capabilities we have is to search for a needle in the haystack, which is the number that's in common to those lists, before we just decrypt any of them, and then target the specific one record or small number of records that's actually relevant, and only decrypt those, and only after proper authorization involving the separation of powers principle, as I mentioned. So finally, the fourth basic kind of technical property that I want to bring up is specifically the idea that warrants should be narrowly targeted. This is, again, deeply embedded in the traditional search warrant process. Part of the inspiration of the Fourth Amendment was specifically the British government's use of general warrants, and of course, even the Constitution doesn't specify a particular number per se, a number of people that should be affected. And there's various, many different ways one could try to define what should be the different. How do you define the difference between a general warrant and a narrowly targeted warrant? Well, I'm not going to try to answer that question, but all I want to say is, if you can answer it, if you can come up with say a reasonable threshold, 10, 100, how many people should one warrant affect? And that might depend on the warrant. That might be partly up to the judge. It might be depend on which authorities get used or whatever. But if you can come up with a number, then our technology can enforce that number before it decrypts actual data, right? So we can do the processing of figuring out, if say law enforcement provides just a list of times and places, and they don't even know, how many people will be common, will appear in common on that list. It might so happen that they accidentally picked the times and places of a Justin Bieber concert, and suddenly they accidentally ingest, hundreds of Bieber fans into their databases, which is totally useless for them and privacy compromising for the Bieber fans, right? So we can, these mechanisms can detect that and can, cancel and cancel the process before the data is actually decrypted, right? So, again, without getting into the details of how this all works, just to summarize, I think, at least these four, traditional constitutional principles: open process, separation of powers, probable cause, and narrow targeting. There's very clear ways that these mechanisms can be, at least technologically, be embedded in surveillance processes. Now, just briefly back to the question. Okay, so. Yeah, that's all I'll say about that particular process for now. I just want to address one other issue. So regarding scope of, say, this particular work. So, like I said, we're focusing on the issue of the metadata issue, in which about searching repositories of metadata, phone records, ISP records that businesses might be holding on behalf of users. I believe this kind of approach is very applicable to that, and it's very potentially, at least technologically, very feasible. There's another, but I want to be very cautious about trying to jump to the conclusion that approach will work in other situations. In particular, the FBI has recently expressed a desire to have a golden key, so-called, to be able to decrypt, anyone's personal device. I believe that's a very different situation for a number of reasons, but the most important one, I believe, being that a cell tower, a landline, a cable modem, a piece of business-run infrastructure has a clear and fixed permanent jurisdiction. We know somebody has to decide what keys, can decrypt, what set of keys can decrypt a given data item. Whereas a device that, say, Google or Apple makes and sells, it gets built somewhere, sold somewhere else, and carried wherever, right? People go from one jurisdiction to another all the time, and if say the U.S. government mandates that Apple include, a golden decryption key in all Apple devices built or sold in the U.S. Well, the first, what's going to happen the first time a user carries their device to, say, France or some other country and gets arrested there, and the local government there says, hey, we want one of those golden keys too, right? So the problem is there's no technical way to create a key that just magically knows who the good guys and bad guys are. There's only the keys, that one authority holds or another authority holds. And if we, and I'm deeply worried that if we try to apply that kind of embed these kinds of keys in mobile personal devices that people that don't have a fixed jurisdiction. Soon, basically, every government in the world is going to want one of those, and they're basically going to have to be embedded in all of the devices any of us take anywhere, which basically puts us in a global race to the bottom in security, where we basically are our security is all subject to the weakest link anywhere in the world. And we've seen exactly that happen with the in other aspects of security, such as the website security system, where companies in Europe got hacked and their master keys to the web basically got used to subvert Gmail, stolen by Iranian activists and used to impersonate Google and things like that. So that's a big problem. So I just want to caution against taking a technology that might plausibly work in one case but then assume it'll work in all other cases. So. Okay, so I will leave it at that for now, and I'm happy to discuss in more detail. Sorry if that was longer and more technical than it should have been, but I'll leave it at that for now. Thank you.
Thank you very much. I am Tim Edgar. Thanks a lot, Brian, for that fantastic description of some of the technical problems with trying to mandate what used to be called key escrow. I like the idea of the golden key. I think that's a good way of describing it. So I'll talk a little bit about that, although you covered some of what I was going to say. But my main contention here is that the choice that we are facing in the wake of the Snowden revelations and in the wake of pervasive cyber insecurity is not really a choice between facilitating wiretapping versus some kind of absolute privacy that I think we all agree we don't have under the Constitution or under any understanding of universal human rights. Those privacy interests have to be balanced against the interests of security and law enforcement as reflected in the Fourth Amendment. Rather, I think the choice is between facilitating wiretapping in a way that could be very insecure and actually increasing our own cybersecurity. That's really the choice that we face. So, in theory, if we could create a system in which only the good guys were able to decrypt encrypted messages, and we could be confident of that, then we could imagine balancing the interests between privacy and the government's need to conduct investigations through traditional mechanisms like checks and balances, judicial warrants, and so forth. In practice, that's not going to work. And the reason it's not going to work is for some of the reasons that Brian has already described. And I think part of the reason that it's hard for us to get our mind around this is that we are really not living in the world that the FBI director might fear the most, the world in which the government is going dark because everyone has almost perfect security on all of their devices and in all of their communications. That's the fear that we've been hearing from the government really since the mid-1990s, and it hasn't come to pass. And I wish I could say that it hasn't come to pass because we've come up with a nirvana that balances those interests, but it really hasn't come to pass because we are living in a golden age of surveillance, as well as in an age of a total lack of cybersecurity. Our communications are, for the most part, not protected by basic technologies such as encryption. And that makes the job of governments very easy, much easier than it has been in the past, and it also makes the job of hackers and criminals and foreign governments who we are trying to protect against very easily. So I want to talk a little bit separately about the issue of gathering large amounts of data, the metadata question, and then accessing individual content, which are legally very different from each other. I agree entirely with Brian's point about the availability of many kind of innovative privacy-enhancing technologies, private information retrieval, and other technologies that can make it possible to access and search large quantities of data without sacrificing the privacy of everyone's data. But I want to talk a little bit more about content. So let's go back and talk about history a little bit. We are living in this golden age of surveillance. The NSA's job has not always been this easy. If you look back at the creation of the organization after World War II, and you look at what the NSA and the British had to accomplish during World War II, it was a tough job to try to surveil and acquire communications of the Germans and the Japanese that were encrypted with what was the best technology at the time. People took communications security very seriously then, and the NSA had, the most advanced technology available, as did the British. One thing that was true then, as well as it is true today, is that even back as far as World War II, and probably farther, I'm sure Brian can tell us exactly when, the availability of theoretically unbreakable communications was there. The ability of people to send messages through what is a rather clumsy device but works, called one-time pads. And so the ability of people, the bad guys, in this case the German and Japanese governments, to engage in communications that really couldn't be broken, even in theory, was there. But because of implementation failures, Allied governments were able to nevertheless get access to that intelligence. Spying on friends was also not something that started in the last few years, as we've been learning from the Snowden revelations. It started a long time ago, pretty much since the beginning of intelligence gathering. One example of that was the secret Venona program in 1943, launched by the Allies, by the British and the Americans to spy on the Soviet Union, which of course at the time was their ally. A later director of the NSA said, you spy on your friends now because you don't know if they're always going to be your friends. And that turned out to be very true about the Soviet Union in 1943. The Soviet Union actually took communications security extremely seriously, but they had a rather massive implementation failure, perhaps understandable as their country was almost, as Moscow and Leningrad were surrounded by German troops. They panicked, essentially, and they did something that was a very basic error. They started reusing one-time pads. And they did this basically because the factories that produced them were just under so much strain from the demand for these one-time pads that they just cut corners and started making them more than once, which, if you know anything about encryption, means that it's totally and completely useless. A one-time pad is completely unbreakable if you use it once, and extremely easy to break if you use it more than once. As a result of this failure, the British and the Americans were able to spy on high-level Soviet communications for several years. But then the Soviets caught up, and they increased their communications security. And a lot of this was because of successful spying on the Americans that the Soviets had been doing. They found out about these intelligence programs. And there's something that's still remembered by maybe very old-time veterans of the NSA these days called Black Friday, not what we just experienced with massive crowds at malls, but a time when the Soviets changed all their codes, improved their security, and suddenly the United States really did go dark. It went black. We couldn't read high-level Soviet communications until well into the 1980s, and then only very targeted communications, things like mobile phones that the Soviet leadership used in their big limousines in Moscow. So there is a real danger of losing intelligence when you're unable to break into an adversary's encrypted communications. There's no doubt about that. And it was a serious blow to American and Allied national security during the Cold War not to have that intelligence available. But I would basically posit that for a lot of the same reasons Brian said, this is kind of a problem that we have to live with. And the fact that the NSA hasn't had to live with this problem nearly as much in the past 10 or 15 years because of a total lack of communication security has maybe lulled us into a false sense that this is the normal way in which national security agencies are supposed to operate. That as long as they have the legal authority to conduct surveillance based either on the fact that they're doing it overseas under Executive Order 12333 or that they've gotten permission of the FISA court and satisfied our laws and our Constitution, that they're sort of entitled to receive all of this data, that's the normal way of things. And that's just not going to be the future in the next 10 or 20 years. And I would argue that our security is actually on balance, going to be improved as a result rather than suffer. Of course, it will suffer as the Allies' government suffered during the Cold War with the lack of access to Soviet communications. But the gains from increased cybersecurity, from the protection of industrial secrets, from the protection of personal privacy, from the protection of classified information networks, better information controls so that we have fewer, certainly not massive industrial scale leaks, which is something which is rather new, is going to be on balance better than having a continued porous system like this. I wish I could say that there was a way in which we could have both, and there are methods, technological methods that can help us have greater privacy and security with still having some law enforcement access, but I think there will be other occasions in which there's a trade-off. So I want to talk a little bit more about the constitutional issues. And really the constitutional issues in encryption, I think, are three. I think it implicates the First Amendment, the Fourth Amendment, and the Fifth Amendment, and I'll touch on those very briefly. The First Amendment is one that we don't talk about a lot, but it's relevant to all forms of national security and intelligence surveillance. Supreme Court has recognized that intelligence surveillance often involves a convergence of First and Fourth Amendment values. It said that in the Keith case in the early 1970s. And the point there is that when people fear that their government is surveilling them for broad reasons, for intelligence reasons as opposed to specific law enforcement investigations, then there's a potential chilling effect on people who have controversial political opinions. And you can see how that happens. Even a well-directed intelligence agency is going to be looking at a pretty broad range of information and is going to be looking, especially today, but even back in the 1970s and earlier, at transnational issues where Americans who have strong opinions about foreign policy issues may fear that those opinions will be surveilled by the government. So that's the First Amendment issue. And another way of looking at it is, okay, so do you have a First Amendment right to use techniques like encryption to prevent yourself from being surveilled for those reasons? The court has not answered that question. Whether use of an encrypted form of speaking is a type of speaking. That is something that is an open question. The next issue, which is perhaps known more about and which Brian already talked about, is the Fourth Amendment. So the Fourth Amendment, we have to remember, really consists of two clauses. The clause that says that the government cannot engage in unreasonable searches and seizures, and then the clause that's called the warrant clause that says that when the government is required to get a warrant, and it's presumed that it usually does, unless there's a well-founded exception, then it has to be specific, particularized, issued by a neutral magistrate, and based on probable cause. That's what the Fourth Amendment requires. Notice it doesn't say anything about the duty of any person to cooperate with the government's efforts to gather information. So the government is on its own when it goes out to get that information. Think of a traditional search warrant. The government wants to search my home. Well, there's all sorts of difficulties they're going to have in doing that. I might have a lock. I might have various security mechanisms. I may be at home and maybe they don't want to alert me. Maybe it's a secret search, what you sometimes called a sneak and peek search. They're going to have to learn how to pick that lock. They're going to have to exercise resources in order to conduct the search. They may not be able to conduct it. Perhaps I have my incriminating documents have been very cleverly hidden, or they've been put in a lockbox, which they don't have the ability to break. The Fourth Amendment doesn't entitle the government to kind of, overcome all those physical obstacles. All it does is give them permission to do it, permission to do something that would otherwise be illegal if a private citizen went in and tried to break into my house. And so if you look at communication surveillance, a very similar kind of issue arises, where how does the government actually get the communication surveillance accomplished? Well, in the old days, it would do very similar things. It would break into a house, in which case it needed a warrant. It would wiretap wires with taps. It is spending a lot of resources to do all of that. And then the courts got themselves in a very fruitless discussion over several decades about whether the particular techniques involved meant that it was a search or not, which was a very fruitless and silly exercise, which they ended in the late 60s. But the Fourth Amendment is really about getting permission. It doesn't really tell us anything about whether a phone company has to cooperate, about whether a landlord has to cooperate, about whether some other entity that's a third party has to cooperate with what the government is doing. All it says is, this is what a search is, and this is when you need a warrant to get the information. Now I'm going to depart a little bit from the Constitution here and veer into statutes, because statutes do actually answer some of these questions. We have surveillance laws, Title III and FISA. They do require people to furnish assistance to the government when they receive an order that is consistent with these Fourth Amendment principles, either because the order they're being asked to, the assistance they're being asked to furnish is not to facilitate a search under the Fourth Amendment, or that if it is to facilitate a search, the government has satisfied those requirements: neutral magistrate, probable cause, specificity. So then a government, Google or Yahoo or Verizon is going to be served with one of these kind of orders, and they're going to have to respond, not because the Fourth Amendment entitles the government to their data, but because the statutes that Congress has passed require them to help the government in this way. So what about the issue of encryption? Well, again, we've been living in the golden age of surveillance, and so it hasn't come up as much as probably people thought in the 1990s it was going to come out when CALEA was passed. CALEA is an unusual exception in our laws. It says that certain highly regulated telecommunications providers, basically the traditional telecommunications providers, are required to engineer their systems so that it is possible for the government to continue to implement the kind of wiretaps that they have in the past. It doesn't apply to a vast array of new companies, including large technology companies like Google and Yahoo, but it also doesn't apply to thousands and thousands of smaller technology companies out there either. And so one question that's been asked is, should it? Should it apply to these companies? And then how would they go about complying with that kind of mandate, that kind of regulation, without sacrificing the security of the services that they're offering? And I guess my contention is, no, it should not. And there's a whole variety of reasons why it shouldn't. One is that basically these companies haven't been regulated in the way that telecommunications companies have been. It would stifle innovation. It would be very difficult to do in a global environment because, as Brian pointed out, once Google or Gmail or Yahoo makes available the potential to decrypt encrypted communications, which they don't offer now, by the way. It's a very easy, this is a hypothetical question for some of them, then everybody else is going to want it too. So there's a whole variety of reasons why it's not a good idea. But the reason I point that out is that I've sort of gone through the Fourth Amendment, I've gone through FISA and Title III. All of these tech companies, even small startup companies, they are subject to those things. They are subject to being issued a search warrant for data that's on their computers. They're subject to being issued a FISA or Title III order that they would then have to furnish us to comply with. What they are not subject to is a regulatory mandate that says that they have to design their services so that it makes it easier for the government to wiretap them. And my contention is that they should not be subject to that mandate. I'm not sure whether the telecoms should either, but at least with the telecoms, we're dealing with an existing regulated industry and not with companies that are manufacturing everything from devices to software as a service to any number of other potential products that are out there. So that brings me to my final sort of legal point, veering back from statutes to the Constitution, and that is the Fifth Amendment. And this is really where kind of the rubber hits the road. I mentioned earlier that the availability of theoretically unbreakable communication has been around for a long time. It was around with one-time pads that were used by intelligence agencies back in the Cold War and even earlier, before the Cold War. But now, that kind of encryption capability is pretty much available to all of you right now. This is different technically, but PGP, which offers essentially commercial encryption, which is not necessarily theoretically unbreakable, but Brian can give you the details about the assumptions that make it very unlikely that you could break that kind of encryption. You can go on the internet right now and you can look for a plugin called Mailvelope, or you can find any other number of tools that allow you to set up a public-private key pair, publish your public key to the world, in which they can encrypt a message with that public key and send it to you. And if your private key is secure, and that's a big if your private key is secure on your device, as these software products are intended to make it, then only you will be able to read it. And even the NSA or the FBI, as far as we know, will have no ability to read that message. So the question is, even if we did pass an expanded version of CALIA that applied to Google, that applied to Yahoo, and applied to for-profit startups and Apple, there's nothing that's ever going to be able to stop anyone, including a terrorist, from using that form of communication to make their communications secure from government. Now, I said I was going to talk about the Fifth Amendment. How does the Fifth Amendment come into play here? Well, if you are the only one who can decrypt your messages, and that would be the correct thing to do from a security standpoint, then there is no third party who can provide assistance to the government. Apple, Google, some other company doesn't have the ability to go to the government and say, here's the key, because they don't have the key. You're the one with the key. They may have set up the system, they may have done other things that might help the government in certain ways, but the government is going to need that key. And unless they can subvert the endpoint, in other words, unless they can hack into your device somehow and defeat its security and extract that key without your knowledge, they're going to have to go to you, and they're going to have to say, please tell us your secret key, or more technically, they'll tell us, please tell us the very strong password you've used to protect your secret key on your device, which we can't break into. And there have been several cases involving this exact fact pattern. Those cases inevitably involve one group of criminals, probably the only group of criminals that has actually practiced good cybersecurity, and that is, very unfortunately, people who have child pornography on their computers. They seem to understand cybersecurity in a way that even ISIS and Al-Qaeda don't. They have been asked to produce their key when there's mysterious encrypted information on their file, which there's pretty good reason to believe may include some pretty vile stuff. And the question for the courts has been whether the act of them producing that information from their brain is an act of self-incrimination under the Fifth Amendment. And I wish I could tell you that there's a very simple answer to that question. That is another question that is relatively open-ended. The argument there, of course, is, hey, I have this information in my brain. You can't compel me to provide it to you, the government. That's what the Fifth Amendment is all about. The government's argument is something along the lines of, if we can somehow shield that, the fact that it was you that provided that key, if we can give you some sort of way of proving that we already know that you know the key, independently of your providing it to us, then they say that they're entitled to that information. Now, you know, that point basically shows how it's never really going to be possible for the government to have full access to every, there's always going to be, as Dan said, is Congress going to allow there to be information that can never be accessed? And the answer is, well, it doesn't really matter. Congress doesn't have the power to repeal the laws of mathematics. So yes, there will be information that the government will never, ever be able to access if it is protected correctly in the way I just described. How much of that is that going to be 90%? Is that going to be 100% of our communications in 10 years? Many people would think that that would be what we should be doing for greater cybersecurity. If we're talking about somewhat lesser versions of security in which keys are managed by third parties, there's another service which is much easier to use than what I've just described to you. And full disclosure, I advise this company. It's called Virtru. Virtru is a plugin that allows you to basically encrypt your messages end-to-end without using PGP, which can be a little cumbersome because you have to set up these key pairs, and then all the people you communicate with also have to set up key pairs. Their business model, the Virtru business model, is really, we think people are not going to do that because the point of email is to be able to communicate with anybody, not just with people that you've previously contacted and set up this device to encrypt. But in order to do that, they had to sacrifice the ability to have dual key encryption. At least they had to sacrifice it for their standard product, and as a result, that means they're managing the keys, or at least somebody has to manage the keys. In this case, they're doing it. They've explored the idea of having somebody else do it as well, or perhaps having somebody do it in different jurisdictions. Those are all opportunities as well. And so then we do still have the same issue of when the government comes and says, we'd like you to give us the key so we can decrypt the messages that are your customers' messages, what is their response going to be? Are they going to fight those? Are they going to, comply? And I worked with them over several months to try to come up with an answer to this question, and basically what we came up with was, if the government comes with a full-blown Fourth Amendment probable cause warrant individually based, that we would comply. But if they came up with anything lesser than that, a subpoena or a big bulk order that said, give us all your keys, or some other kind of mechanism, that even if they had a plausible legal argument, we would fight that. And so, I think that over the next 5 to 10 years, as industry and ordinary people take back their privacy and start using these encryption technologies, we are going to be shifting away from this world that we've been living in for 15 or 20 years, which I've called the golden age of surveillance. And we're going to recognize that that is not actually the normal way of the world is supposed to work. That is not how it has worked before that time. Security is going to be much, much tighter, and the government is going to suffer some loss of intelligence as a result of that. But it is not going to be the dystopia that the FBI director or the NSA director are most worried about. It is not going to be a world in which they completely go dark, because there will be many other entities out there. There will be many flaws in the way people implement these technologies. There will be companies like the one I'm telling you about, or other companies whose cooperation they can compel. And so it's going to be harder for them to get surveillance than it is now. Maybe they'll have to target their surveillance more at particular people. And perhaps one way of resolving this dilemma, going back to what Brian was saying earlier, is for the government and the technology and computer science communities to get together and say, hey, you guys have been enjoying the bonanza of a golden age of surveillance, but you've also been experiencing serious cybersecurity problems and a loss of privacy. Maybe rather than coming up with new mandates for the technology industry and telling them you have to come up with ways that we can continue to wiretap you, what there should be is a dialogue where the technology industry says, here's some things you've been doing that we find very uncomfortable, and here are some ways you could do the same thing with privacy-enhancing technologies. And on the other hand, the technology industry can say, and if you're willing to work with us on some of this stuff, we're willing to work with you on sensible and reasonable policies for what you're going to have to be facing when you're going after people who are genuinely bad guys who are now actually using some of these security tools. We're not going to be able to promise you that you're always going to be successful because some of these guys are going to do a good job of implementing their security. But there could be, with open and transparent dialogue between these two communities, I think there's a real chance for some progress. So thank you.
Timothy, thank you very much. So ladies and gentlemen, I think we've actually had a rather excellent discussion today. Brian has given us a very good tour de horizon of the technological aspects of this as well as procedures. Dan actually set the scene for us in terms of the current context and over the past few years, and Timothy has given us a great historical overview as well as also a foresight of the new realities that we face in this area. So I'm going to open the floor up to questions, and we have about 15 minutes for questions. I would ask that when I identify you, please wait for the microphone that's going to be handed to you by Helen, and then also identify yourself by name and affiliation. You may find that the microphone doesn't necessarily broadcast, as it were. It's actually for the video, so if you could please speak clearly and loudly, that'd be great. I see one question already from the floor, but I'm actually going to give Dan Gallington the first question, then I recognize the person on the floor. So Dan.
My question is the device problem that you identify, is that solvable? Assuming you want to...
I've thought about that. So to my knowledge, not with current technology or, not with the current state of technology that's out there and available or kind of plausible anytime soon. In principle, it's possible. I've thought of, kind of ways hypothetically, devices could be made that they somehow securely know what jurisdiction they're in at a given time and what, set of laws their users are, subject to at a given moment. But this is totally hypothetical because if we tried to implement that today, the first thing any foreign intelligence agency or criminal organization would do is come up with fancier GPS spammers, say GPS spoofers that we know are already possible. They would come out with these like they already come out with fake cellular base stations in order to fool your laptop or your mobile device into thinking that it's in Syria or Iran where they have the keys for, right? So that's kind of where I've gotten so far.
Part B. Do you believe? I'm asking you from your professional point of view. Do you believe that these cryptography programs are perfect?
Nothing's perfect. Definitely not the cryptography. So,
in other words, when Apple says, when you put data in here, not your calls, but when you put data in here, that nobody can get it. Do you believe that?
In practice, no. So all, and there's many, there's many levels to the answer to that question. So the only form of cryptography that we know to be absolutely unbreakable is what Tim referred to, which is what we call information theoretic cryptography, which unfortunately is completely impractical, kind of in normal use. So no actual devices use that form of perfect cryptography. And all the practical cryptography that we know how to do, we know could have some weaknesses. Somebody could, come up with break AES or RSA or DSA or elliptic curves tomorrow. Maybe somebody has already broken them and just hasn't told us about it. But I think the general consensus is that no, for the basic math that's out there that's being used underlying the current state-of-the-art device encryption, the basic math and algorithms are good. I don't think it's likely that anybody has broken them. On the other hand, the surrounding, like Tim alluded to a number of times, the surrounding technology, the implementation of those technologies, the operating systems and applications in the devices that use those are so hopelessly, flawed in so many ways. Every time a new bug comes out, that's typically a new way an attacker could get in and break the key and steal the data, completely circumventing the mathematics, right?
And I think also just I think there needs to be a distinction between, there's a lot of controversy because of the Snowden revelations about the NSA breaking various types of encryption methods, and I think there needs to be a distinction between an intelligence or law enforcement agency taking advantage of flaws to conduct lawful surveillance, and there's a legitimate question as to whether they should then have an obligation to disclose those flaws if they're not generally known. If they are known, I think there's very little actual controversy there because they're just taking advantage of flaws, versus making an entire system more flawed through introducing into that system, whether in the supply chain or in the algorithm itself has been alleged in certain cases, certain flaws. Because in that second group, you're actually making everything less secure for everybody. Whereas in the first group, what you're doing is you're basically just fighting this battle where, I think that those of us who do support privacy but also want the government to catch the bad guys, we can't tie their hands behind their back and say you can never break into anything. I mean, that's the whole point. That's what they're supposed to be doing. So I think those are important distinctions. And when Brian talks about potential flaws in AES or RSA or other kinds of common encryption algorithms, I mean, part of this is the care to which computer scientists go in saying, I cannot prove mathematically that this can never be broken, versus saying, we've got some assumptions here, and this would be, if anyone broke it in the public arena, this would be front page news, tomorrow. So we can be pretty confident, and I wish that, I wish that I could say that the NSA were such geniuses that they could keep something like that secret for 10 years and that they've done it and they're smarter than everybody else. I think that's not true. So there are, basically secure methods. I guess what I'm saying is that I don't think we should comfort ourselves with the notion that no one will ever be able to be secure, and therefore we don't have to worry about it because the government will always be able to exploit a flaw. Maybe in a general sense that's true, but in specific instances they won't be able to exploit it because it'll be done correctly.
Okay, the gentleman at the table here.
Yes, my name is Roger Cochetti. I work with internet investors and have been involved in this issue for IBM, VeriSign, CompTIA, a number of companies since I guess the Jurassic period of the internet when Alta Vista was the principal search engine. So I've actually got a question for each of you, if I if I may, and the brief questions. But first, I wanted to ask Tim. You began your comments talking about the international dimension of this, and there's a very important international aspect of this which does not get much attention, and that is among the Snowden revelations that got the most emphatic response was the one that the United States government was monitoring the government of Germany. Anyone who does business in Germany knows that this hit a chord among the German people and the German political community. And the nominal answer to this was, well, Germany declined to join the Five Eyes. So we have publicly said we will not spy on New Zealand, Australia, Canada, Britain, because they're part of our club. But anybody outside of that club is fair game unless you join the club, which Germany has declined to do. From the German point of view, this sounds like you're really in the same category as Pakistan and Indonesia and Egypt. We really can't trust you, and so far the U.S. position has been, we're sorry we have to do this, but we have to do it. So I think it's a big and growing issue in U.S.-German relations, and I wonder if you could comment on how you see this being resolved, and is it possible that the United States government would permanently, publicly say, here's a list of countries that are not part of this mutual club, but we like them so much, we will never spy on their government agencies.
Yeah, we actually don't actually do that even with the Five Eyes. There's a provision in the agreement that makes it clear that we reserve certain sovereign rights to each other, but that may be a more technical point. I was certainly surprised at the German operations because of the extremely close relationship in defense and intelligence issues with the German government. I think it shows you that even if things are legal, constitutional, they're often intensely bad ideas from a policy standpoint. My feeling is that if you want to know what Angela Merkel thinks about an issue and you're the President of the United States, you should call her on the phone and not be reading reports about what she said. Obviously, there's some advantage to being able to monitor the person who is, after all, the most powerful woman in the world. There's undoubtedly foreign intelligence there. And of course, allies do spy on each other. But I think that was, there did not seem to have been any real assessment. I think this is an indictment not of cryptography, but of just bureaucracy. There does not seem to have been an assessment or even a process for assessing in the intelligence community the danger to international relations from blowback versus the benefit of the intelligence that's gathered. No doubt there was good intelligence gathered, but the dangers obviously were far out.
So is there a solution to this problem?
Well, that's a bureaucratic solution, which I think that actually has already been changed in the sense that the president has issued various directives that, tell the intelligence community, hey, you guys better make an assessment here before you do these kinds of things.
Okay, that's not the way the Germans hear it, I guess. So
Go ahead.
I think one of the most profitable things the Germans could be doing, and I hope they are doing this, is having a dialogue with their own intelligence agencies. I think that would be the most productive way for them to assess the significance of this revelation. And if they did that, they would soon discover that the intricate oversight mechanisms that we have in this country, just for example, are not replicated in their own country, and they would profit from a dialogue, as I said, between their elected government, their political government, and their intelligence agencies. They would learn a lot if they did that, and I think some of the criticism demonstrates that they really don't understand their own bureaucracy.
Well, it also demonstrates the fact that our intelligence oversight network is mostly about protecting the rights of U.S. persons,
Yes.
and that doesn't give much comfort to Germans or others who are not U.S. persons. In January of this year, President Obama issued PPD 28, which was, I think, actually a major watershed for intelligence oversight, because for the first time, the U.S. government, and I believe any government in the world, issued a directive that said we are going to take into account the privacy interests of non-U.S. persons. We're going to have privacy rules that protect them, charge the DNI with developing those rules. And, there's probably less likelihood in the next Congress for legislative changes than there was in this Congress. But this PPD may actually be more important in the long run, even than some of the changes that were being promoted by Senator Leahy, I think.
And Tim and I agree on 99% of the things here. But one thing I would mention in context of that is that U.S. persons includes anybody who's here legally to begin with. And a lot of Americans don't understand that. And they hear this U.S. persons, they think we're talking about citizens. Anyone who's here in this country.
I didn't want to belabor it, but I guess I would just say that I think what the German political community wanted to hear, which they've not heard, is we will treat you exactly the same way we treat Canada, New Zealand, Australia, and Britain. If they heard that, the issue would stop. They have not heard that. So anyway, if I can just quickly ask Brian a question.
Please do.
I have some concern, having been involved in the issue for a few years, with the notion that there's a technological fix on the issue of mass surveillance, because although you use the example...
I would not say that,
Well,
but go
but
ahead. I wouldn't put it that way, for sure.
Thank you, because that's what I was hoping you would say, because the example you used was the one in which the bad guy was dumb enough to use the same cell phone continuously throughout all of his crimes. And anybody who watches even House of Cards knows that Frank Underwood, or Breaking Bad knows that Saul the attorney keeps a drawer full of temporary cell phones, and every time they use it, they throw it away so that they can't be tracked. But that leads to the point that the thin type of mass surveillance that you were talking about, just metadata, quickly falls apart when the bad guys are smart enough to just keep getting new email addresses and new cell phones. And then you have to go to the next layer, which is, well, I have to see the haystack here is not just the phone numbers. The haystack here is the content of the messages, because I have to scan the content of all the messages to find out what's actually going on. So I happen to believe that the concern I have with the technological discussion is that it helps avoid what I think is the sort of core policy decision that has to be made, and that is what's more important. And that is, it's either privacy or security. You do your best to have both, but something is first and something is second. And I think that the Ben Franklins and the James Madisons and the Thomas Jeffersons all understood this perfectly when they said yes, if you can have general warrants, you will be much, much more effective in getting the bad guys. Because if I can examine every house in the city, then I'll get every bad guy. But you know what? It's not worth it. We'll put up with the bad guys who are hiding in order to not have that. So I don't think that the issue of needle in a haystack is unique to the internet. I think General Cornwallis said, I can't find out who the rebels are in Boston unless I can look at the whole haystack, and then I'll find out as I examine it. So I think it's an old issue, and I think that the technological discussion shouldn't in any way lead people to think you can have your cake and eat it too, because I think at the end of the day we have to have a priority and live with the consequences of that. So that's my observation. Thanks.
Yeah. So I'm glad you brought the kind of burner phone example up. So it's absolutely true that no particular kind of combination of technology is going to solve the problem and, for example, give the law enforcement complete access to everything they might ever want to. And I think I completely agree with Tim's point that the government has never been and shouldn't be considered to be entitled to any information they might ever want. On the other hand, say the burner phone example you brought up is an interesting example because it actually comes back and illustrates the point that I was trying to make, probably imperfectly, about the general usefulness of a small number of potentially open technological processes. For example, the burner phone example, in the last year's leaks, we've learned some interesting formally secret processes about how the NSA tracks and can actually discover burner phones, and they by tracking metadata. They don't do that by, there's no pattern in the phone numbers that that tells them this is a burner phone, right? They, at least, maybe there is, but that's a different thing that I'm not aware of. But what we have learned is there are processes by which they can use these kind of what we call intersection capabilities, just combining lists together and see what matches up across different lists of relevance, and discover that somebody was over here and using this phone for a while, and then that phone stopped being using, but another phone started getting used at exactly the same place a little bit later. And that's only metadata analysis. They don't need the content to get that. And furthermore, the same basic process of comparing lists that we can do with this one, with one open, potentially open privacy-preserving process would also support that. And I would conjecture that if that process had been in place, and it was potentially openly known to everyone, it had been debated and written into public law that, the government is going to be able to trigger this, this privacy-preserving search process that can compare lists and, find something like that, the NSA would have its secret method of using that process of this very fancy amazing, very cool secret method of using that process to find burner phones, and that would still be secret now because Snowden wouldn't have gotten disgruntled and decide to leak it. And maybe that would have been a better thing for law enforcement and for everyone. And that and many other potentially secret methods can use a very small number of privacy preserving processes to great effect. Now, that said, I completely agree with you. They're not going to do everything that, and they're not going to magically give law enforcement access to everything that they might possibly want. But I don't think we should, at any rate, discount the potential power of those kinds of mechanisms if implemented correctly, right?
We have time for one more question. Any other questions? Yep.
Hey, my name is Jacob Herger. I'm from the New Atlantis Journal of Technology and Society. I just was wondering if you could elaborate briefly on what you thought the fate of NSA reform will be in the next Congress, and if before the sunset next summer, and if nothing happens in Congress, what alternative federal channels of reform do you think will come to pass?
Well, so for I'll take that. It was a disappointment, I think, to the coalition that was supporting legislative changes because, 58 votes is apparently not, and a majority of the House is apparently not enough to pass legislation. And there's going to be a lot fewer votes, most likely, in the Senate coming in January for that legislation. So it's going to have to be very substantially modified if it's going to have a chance of passing. It was really kind of a unique moment. I had been doing lobbying for the ACLU before I joined the government, and so I can tell you that it is extremely rare to have the support of the ACLU, the NRA, Google, other technology companies, Senator Dianne Feinstein, Senator Patrick Leahy, and the intelligence community for a single piece of legislation. I don't think that has ever happened before. And the fact that that legislation couldn't get through Congress is kind of extraordinary. It's hard to imagine who else could have been supporting it in order to get it passed. So I'm very pessimistic about surveillance reform in the next Congress. There will have to be something because the Section 215 that supports the large phone metadata program will expire in the middle of next year. And I cannot imagine that Congress will allow that simply to go away.
I disagree. I think they will. I think that'll be the solution.
I think that's extremely unlikely.
Oh, really?
I mean, if you think that if you're going to filibuster legislation because you think that it's going to help ISIS to have a new modified program of gathering metadata, then my goodness, you're certainly not going to end it. I don't think I think it's extremely unlikely that sunset will simply expire. I think it will be renewed, probably with relatively minimal reforms, and that will be a big disappointment to a lot of people. As to what other avenues are available, who knows? I think it's we still have court cases that are pending. There's still an opportunity for additional executive branch action.
Right. There's two, as I understand the legal debate now. There's one line of cases that say it's unconstitutional. The other line says it's constitutional. They're working their way up, and whether or not they'll actually get to the Supreme Court, we don't know. You have issues of justiciability, political question, and standing that seem to affect cases like that. So whether or not that'll ever be decided, what's the Maryland case that?
Well, yeah, I think Smith v. Maryland. I mean, I think that's just such a kind of embedded in all sorts of aspects of surveillance law. I just cannot imagine the Supreme Court simply overturning that case. I could see them distinguishing it or modifying it, particularly as it affects internet metadata, which is really not an issue for the phone records program. But I think that the issue of internet metadata is an intriguing one, where you could make a lot of arguments that that would distinguish Smith to the telephone context.
Okay, I'm going to have to just say that if you're looking for a historical context, at least from a philosophical point of view, read your Jeremy Bentham on these issues. certainly this debate has long reminded me of my political philosophy classes on Bentham, and I'm now glad to say that actually there was a point to those lessons. So, so as the delicate mosquito of time meets with the windshield of fate, and as the computer worm of spite crawls up the ear hole of despair, I'm afraid I must bring this session to an end. I'd like to thank our panelists, Tim Edgar, Brian Ford and Dan Gallington for their comments. Thank you all as well for coming out on such a miserable day and joining us for this discussion. I hope at the very least you enjoyed the discussion as well as the lunch, and please keep a lookout on our website for future events on this. Thank you very much.